The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources to help you decide whether or not you actually might want to handle some issues yourself. Perhaps you do need to contact a lawyer. Either way, you'll be better prepared, and so will the professionals who you select. Our goal, of course, is to help you save time, money, and of course achieve better results, or the best possible results. We want to welcome and thank David Bazar, attorney.
Thank you.
Bazar. Thank you from the Bazar and Associates law firm in East Providence, who continually gives us his insights and facts on the various cases and kinds of topics that we will discuss. And today, a topic that's important to many of you, real estate. Are you purchasing or selling a home? Commercial property, borrowing money for either one of them. You want to be a smart shopper and you don't want to be scammed. So what should you do before you invest or before you sell? So today we want to provide an overview, give you some of the do's and don'ts, answer some of the questions that are typically listed in the FAQ, frequently asked questions. Both residential and commercial. So let's just start. Basically, what is real estate law? What does it cover, David?
Well, real estate law really is a wide topic, and it can cover anything from purchase and sale of real estate, which you mentioned at the beginning, to litigation over real estate in terms of adverse possession, which is a form of ownership, zoning issues that can come up with real estate use. So as I say, it's a wide variety of different issues. So perhaps if you want to concentrate on one, we could start with that.
Let's see how we go with that. I know we say to our viewers that we always want to provide resources in case they decide to do it themselves, and there are websites such as realestatefindlaw.com, and some of them will even tell you things that you'll want to bring to your attorney. David, is it, whether it's residential or commercial, would you say flatly that's something that somewhere along the line everyone needs to have a lawyer to help them with and must legally have a lawyer?
Well, okay. Let's concentrate, and we'll start with purchase and sales.
Okay,
right?
good place to start.
And residential or commercial. Mm-hmm. So starting with the seller of either one, do you necessarily need an attorney? Maybe not. If you're sophisticated and you know how to read financial documents and legal documents and you're comfortable with doing that. But there are some things that the buyer's attorney may be able to draft for you, so you'll end up paying some legal fees anyway, such as the deed or a seller's affidavit or a taxpayer, an affidavit as to your tax ID number and your residency, so they call it a seller's residency affidavit. And these types of documents you might be able to get online, you might be able to do, but certainly the deed itself is going to have to pass muster with the buyer's attorney. So there's a lot of things that need to go into it and that have to be done correctly. So on the seller's end, do I need a lawyer? Probably. Can I maybe do it without a lawyer? Perhaps.
And what about at the closing? If you are having any kind of financing done, doesn't that institution that is handling it, don't they always have a closing attorney there, so there's always one interjected somewhere along the line?
Right. So the buyer's side, which is where the bank will be involved, is going to require an attorney. What they have to do is to allow the buyer to select their own attorney if they want to. And you should if you know attorneys, and you can perhaps price things out a little bit, but there's fairly standard charges in this area. So your most important aspect with that is to hire someone who does that kind of work and knows what they're doing and is registered or authorized to issue a title policy, which is the title insurance that the bank will require. And if it's a first-time purchase, not a refinance, you probably should buy it too. So you probably need to know what title insurance is and why you should get it. And what title insurance is you're protecting the title. You're ensuring that the title that you're buying in your name is good and that there are no claims against it from either prior lien holders, mortgage holders, other people who in the title line never signed off. When you buy property, a title search is done. And what that is you're searching the records for all of the prior owners to make sure all of the documents were properly executed and recorded so that good title can pass to you when you buy it.
Yes, I was about to say, let's start, maybe we'll tackle the residential first. And once someone decides that they want to buy a piece of property, among the many contracts and things that they have to look at, is it the title that's first issue that they have to deal with? And is that something that they do on their own, or flesh that out a bit?
Okay. Most people, when they buy a home, enter into a purchase and sales agreement. That's the first legal document in the chain of legal documents that you're going to sign. They're standard, usually produced by the broker. If there's a broker involved, if there's no broker, you probably ought to contact an attorney, so a properly drafted purchase and sales agreement can be drafted. And that document is the document that controls the agreement between the seller and the buyer. How much is the purchase price going to be? What contingencies are there for inspections, mortgage, other types of contingencies that you may or may not have in the particular property. Massachusetts, septic systems are always an issue, and there is rules on that. So given all of those issues, I would always have an attorney, at least if there's no broker involved, draft the purchase and sales agreement. If there's a broker involved, the document's usually a pretty standard document that the broker has dealt with hundreds, if not thousands of times, and they can probably walk you through it initially. Personally, I would still have an attorney review it. So once the purchase and sales document is executed, usually there's a mortgage contingency. So the next step is finding a mortgage company, whether it's a bank or a mortgage broker or some legitimate lender of money. And you want to be careful with that, because if you've got good credit, there's no reason not to go to a bank or a credit union or some institution where you can find rates advertised and upfront and know what you're doing, and rates are still very good. So it's a very good time to be competitive in shopping mortgages. You don't want to apply for more than one mortgage, because every time you apply, they check your credit and it dings your credit report, and so sometimes you'll see credit denial, too many inquiries. But in any event, so the next step is to apply for that mortgage. And one of the things you have to be careful with is, what is the mortgage contingency, that's one of the outs to the agreement. And you have to make sure you comply with it. Good faith application for the mortgage. If the mortgage is denied, to let the other side know in a reasonable time frame, which is spelled out usually in the document. My mortgage was denied, so I am declaring the purchase and sales agreement null and void. I want my deposit back.
And if it's not in writing, I understand that that could be a matter of dispute if it hadn't been in writing in the first place. And another reason alone to have a lawyer.
Right. And real estate deals, real estate transactions, statute of frauds requires that a transaction for real estate be in writing. What that means can be the subject of debate many times. Is a contract written on a napkin for the purchase of sales of a property enforceable? And I've taught these classes before, and I've seen many cases involving this, and as long as the parties have the requisite intent and the details are spelled out sufficiently, that can be an enforceable document. Can emails back and forth create an enforceable document? Perhaps, maybe not. Are they signed? And the statute of frauds only requires the signature of the person who the contract is being enforced against, so that if you signed it and I didn't, and I'm suing you, then it's probably an enforceable agreement because you signed it. If I didn't sign it, probably not if you try to enforce it.
Another good reason that you might want to be checking with a lawyer. So earlier on you were mentioning that if you happen to be in good financial standing, you mentioned how you should be able to go to a bank or a financial institution and have a decent rate. Of course, in the spate of foreclosures and terrible mortgage issues, there were many new laws that came up, which of course were now intended to make sure that the mortgage originators weren't doing some underhanded things that we need not enumerate right now. But when you mentioned earlier the good faith agreement, good faith estimate, apparently that's a very interesting document. David, could you just elaborate on that just a bit? Because apparently that's one where there are more unpleasant surprises if there weren't one. what does that entail?
Right. So as you were talking about some of the changes in what needs to be disclosed that have come
RESPA,
up.
as they call it.
Well, we used to have a HUD form which
Yes,
laid out
HUD
the numbers for both the seller and the buyer, and that form has changed to a CD, a disclosure, closing disclosure document, which lays out the numbers in a little different way. And being, a creature of habit, many of the real estate lawyers, myself included, who have, gone through the change, it's fine now that you're used to it, but when you first see it, wait, those numbers aren't where I'm used to seeing them. Can I see it the old way? But it's the same numbers in a different spot. But there's also, as you said, the disclosures of the good faith estimate, where these are what you should expect for closing costs, title fee, title insurance, recording fees, the loan costs, which can be points, which prepaid interest, or 1.1% of the loan, that type of thing. The escrows, or impounds, if you will, that's the money that they have to hold because you're escrowing your taxes and insurance. All of those numbers can be put on a form, and I'll put on a form that you can look at, and that's what I was talking about. If you're good at reading those forms, fine, but as the buyer, you need an attorney anyway, so they'll be there to explain that all to you.
And that money, whatever that's supposed to be at the time of closing, presuming that everything else has gone as planned and there were no other unpleasant surprises along the way, which perhaps we should discuss too, but the buyer should know when he walks in the door for the closing how much more it's actually going to cost him, and it shouldn't be, 3 hours before the meeting, so
Right.
that he somehow has to find a way to get another $10,000 or whatever that might
Right.
cost.
And the numbers shouldn't be significantly different than what's already been laid out to you. So that is a good change, and it is a good thing to know. I've got to come to the closing with a certified check for $10,000, then you know that up front and you're able to get it and have that in place. Yes, that is correct. There could be some changes, though, at the closing, because when you buy the residential property and the buyer goes through a walkthrough and everything was fine when they first saw it, but now they come through and there's some significant difference or change, or something's broken and they want an adjustment to it at the closing. So those adjustments can still happen.
So in talking about that, what happens if you have purchased a home and then you find something inside that you didn't know before is faulty? Do you have any recourse? Presumably there are inspections. When does that happen? Who's at fault? Who's liable? Who has to pay? What happens with that, David?
So in the standard purchase and sales agreement, residential property, there are paragraphs that either the attorney will draft and put in, or in the broker's forms, that talk about the right to inspection, when the inspection needs to take place by, and what the results of the inspection can create as in terms of voiding an agreement or having changes to the agreement. So typically, an inspection has to be done early on in the process, and if the inspection reveals things that are of significant concern, the buyer's attorney or buyer would contact the seller's broker, their broker, seller's broker, or seller's attorney, and say, we didn't know that the roof had 3 layers on it, and this is going to have to be replaced, and it's going to be $15,000, and we want an adjustment made. Now, usually in the agreement, what it will say is the seller then has the option of saying, I'll replace it, if that's part of what would be done. I'll give you the credit, or I will back out of the agreement.
Who pays for that inspection, David?
The buyer,
Always?
usually. Anything's negotiable, but typically, yes, the buyer.
And apart from having an inspector, is it worthwhile to have, if it's a house rather than just land, to have a contractor in addition to an inspector? Because
Well-
the contractor might be more likely to say, this may pass muster, but did you know?
Right.
Whatever.
Usually, if you have a good inspector, it's as good as having a contractor, because
Okay.
they know what to look for, they know what the issues are. But when I buy real estate, I always have an inspector, or an inspection done by an inspector, because they're usually insured, and bonded or whatever, so that if they make a mistake, there's someone that you can have a claim against if it's a significant thing. Although their contracts are very interesting, that's a whole nother show, but they sometimes try to limit their liability to the cost of the inspection. Can they do that? Maybe we ought to take a closer look at those agreements too. But I also have a contractor friend of mine that I bring just because I want a second set of eyes and I trust him, and if I'm going to do any work, he's going to do it, so I want to know what he thinks up front too.
That's why I was asking too. Might they do it at the same time?
Sure, why not?
Tag team?
The seller, if the seller's still living there, doesn't want to be interrupted too often, so usually that's the best way to do it.
When you're purchasing land, maybe not an entire home, what kinds of things do you have to be aware of in that case?
So what are you buying and why are you buying it? If you're buying a piece of land to build a home on, then you have to make sure that it's zoned properly to build the home. You have to make sure it's big enough to be a buildable lot. You have to make sure it passes a perk test, as they call it, which makes sure it drains properly. If it's going to be a home that's going to be connected to a sewer, you have to make sure that there's a connection to it. Real estate has to have access to a road, and it's really not even sellable or saleable, as they say, if it's not road front access. So those are the types of things, and if you're building on it, perhaps you need to know if there's ledge or what type of property it is, so that you know what kind of site preparation work has to be done to be able to build. So again, that's one where you definitely would want whoever you might hire as a builder to look at some of those things with you too, as well as whatever inspectors would need to do that.
And David, when someone buys a piece of land, they may have a conversation with the seller about the zoning, and you said it needs to be checked, but what kind of recourse would the buyer have if after the sale goes through, shortly thereafter, suddenly that land across the street now becomes a big box store, or something, it suddenly gets rezoned so that things that they would not have liked are about to happen? Any recourse?
After the fact,
After the fact.
if the buyer didn't check or could have checked and didn't find out, and the seller didn't know, then no, probably not. If the seller knew and withheld information that you would otherwise expect them to turn over to the buyer, and the buyer would have had no other way to find out, then maybe you have a fraud claim or something of that nature. But it's a difficult case, probably, depending on the circumstances.
Okay, and the topic of easements, explain that, what it means relative to land only, and also the property that has land around it.
Okay,
What's an
so easements can come in many different forms and many different reasons. Typically, you'll see an easement for utilities. So you may have a development where one property can't get its utilities directly for one reason or another, so they have an easement for the utility to pass through your property. Sometimes power lines go through people's properties, and there's an easement from the utility company for the power line to pass through. So an easement is a right for one party to use another party's property. Another typical easement would be to get to real estate that's not, like I said, it's supposed to have access to the street. At one time, I had an interest in a piece of property that didn't actually have street access. So we had an easement that ran through the next lot. At one time, the lot was owned by one person, one big lot. And when he broke them up, the lot that our building was built on had an easement in perpetuity, which forever, that ran through the next lot with a right for our clients and anybody else to pass and repass, as they say, over the other lot to get to the street. So an easement can be in perpetuity. It can be for a number of years, depending on what it's for. It can be created by prescription, they call it, which is another form of adverse possession. So a case that was in a law class that I taught talked about beach homes in the lakefront, and the people who didn't live on the lakefront always had the right to cross over the property down a path to the lake, which was owned by one of the lakefront owners. And over the course of time, all the people around obtained an easement by prescription, by use, for the right to do that. And at one time, when the landowner tried to stop it, the lawsuit was brought, and it was found that nope, this right had been given to all the owners in the development over the course of time.
Would a title search have uncovered that?
No, not that one. But a title search would have uncovered the easement in perpetuity that the property that I owned an interest and had with the other properties, because that easement was recorded when it was created. And it needed to be, because in order for that land to be sellable and viable, it needed to have that right of pass.
And if you are working with a client who sees that there's an easement on their property, they're the property owner, is it a lawyer's responsibility to explain to that person who's now has that property, that means that you can't put that fence up to prevent passage
Right.
to the lake or
Right.
waterfront or whatever?
Yeah, if it's something that's discoverable through a title search, then certainly the attorney is going to reveal that. Condominiums have different rules and different regulations and different prohibitions in condominium documents, so oftentimes those have to be reviewed so that the person knows that if they put their trash out, it has to be covered. If they wanted to put up a fence, which maybe they can do, it has to be painted white if that's what the requirements are. So whatever uses that, or anything that inhibits the use of land in one form or another, or has some easement or prohibition of use in any form, has to be revealed, and that's something that you have to consider when you buy it.
And in terms of disclosure and honesty, transparency, if you are looking to sell a home or buy a home, sometimes there are flaws in either way. What are you obliged to share with someone? How much?
So there's forms that are generated when you list a home for sale that discloses all the known defects, and it's an exhaustive list of questions. So if you know about something, you have to put it down. If you don't know, obviously you don't know. Sometimes there are homes that are sold by an estate, for example, where the person who owned the home died and the estate now, through the administrator or the executor, is selling the property, and they legitimately don't know some of these things, so they can't answer. But that's a buyer beware situation.
And what about, considering there had been so many foreclosures once upon a time, or it seems not so long ago, houses are then sold as is. What happens to known and identifiable defects?
Yeah, that's a thing where banks don't want any responsibility, so if they're selling it as property they foreclosed on, then you know what you're buying, and it's your risk.
If you were looking at the property, looks fine, you see that there's pipes, but oops, they happen to be copper pipes, and between the time that you thought you were going to buy it and the time that you're ready to close on it and or move into it, if that's the case, suddenly they're gone. What
Right.
happens? Is that still an as-is and you're out of luck?
That might be a reason to be able to back out. Again, the terms of the agreement are going to control that, and there should be something in the agreement for risk of loss. So it doesn't have to be just stolen pipes. It could be fire or damage to the property, and who's going to bear that risk of loss, the buyer or the seller? Usually the seller bears the risk of loss because he has the insurable interest and can insure the property against the risk. So if there were copper pipes and they were stolen and you've insured against that and you're the seller, you can then either say to the buyer, look, here's the value of what we're getting from the insurance company, buy it and we turn that over to you, or make some other arrangements.
And now as you're mentioning it, David, what is the reason for, or I guess value in, someone on either side having insurance while this process is going on?
Certainly, and again, let's look at the contract and what's the agreement that we made. Generally, residential real estate, the seller is going to maintain his insurance until the property is sold. Can a buyer get insurance? I suppose if the contract's written in a certain way, that's possible.
Well, the buyer has realized that certain things needed to be done and they weren't. That's part of the agreement, but it also, is that something that needs to be covered by insurance so that somewhere the buyer has some restitution, whether he sues or doesn't want to buy the property, or whether he just in some way is made whole by insurance? Is there a reason to do it on that side of the fence?
That's not a type of situation, as I understand what you're asking, where insurance would even be available.
Not even available at that point.
What I was talking about as an insurable interest is to protect against the loss of the property by fire, casualty.
While it's going on, okay.
But even that, usually, that insurable interest doesn't pass to the seller the buyer until they sell. That's why the seller maintains it. But that's one of the clauses where the lawyer really needs to look at it carefully for you and explain what you can and cannot do and what you can expect.
Okay, and when someone buys a property, there are different kinds of deeds. There are different ways that someone might own it. Own as sole owner, joint tenants. Explain some
Okay.
of those, and then we'll
So-
go on to commercial as we can.
So the different forms of ownership, which are when you're the buyer, the seller deeds it to you as, if it's just you, you're the only owner, so sole owner. If you're buying it with a spouse, tenants by the entireties, which is the best form of protection because the property passes to your spouse upon your death automatically, and creditors have a hard time attaching that property to make a claim against one person who owns it. For example, if your husband owns it with you, tenants by the entireties, and his creditor tries to attach the property and he dies and it then passes to you, whatever lien was put on the property against him is automatically removed, tenants by the entireties. Joint tenants with right of survivorship, same thing, it passes, but the creditor protection's not as great. And you could also own it tenants in common, which mean you each own an individual, undivided, if it's two of you, 1/2 interest. So you can leave your share to whoever you want, and the other owner can leave his or her share to whoever they want.
And while we don't have much time to cover commercial today, explain, is there a difference in state to state joint tenants, tenants in common? Do people really need to be aware of that when they're buying in various states, or is that pretty much consistent throughout every state, however the law is set? Are there
Right.
variations in each state?
So, two things. Number one, probably not enough time to even touch commercial.
Exactly.
So, real estate law is very much a state law predicated thing. So, yes, you need to know the law of each state, wherever the real estate is located, and the law that usually applies to anything with real estate is the law in which the real estate is located. The other thing I'll touch on, because we do have a little bit of time, is what type of deed you get, because people will say quitclaim deed, warranty deed, executor's deed, all those types of things, trustee's deed. So a quitclaim deed versus a warranty deed simply is, if I sell you a piece of real estate by quitclaim deed, the only thing I'm guaranteeing to you is I'm transferring to you whatever interest I own. I'm not making any other warranties or guarantees, whereas a warranty deed says, I'm warranting to you the title, the right for me to transfer it, all those things. Trustee deed simply is a deed that's transferred from a trust by the trustee. An administrator or executor's deed is a property being transferred from an estate of someone who died usually.
And isn't it quickly true that in divorces, when there are settlements, that quit claim
Usually it's
is
quitclaim
the
deed.
one that's
Usually.
most commonly used?
And actually, I've had cases where someone refuses to sign the quitclaim deed, so you can get an order from the court, and there's a statute that allows the property to be transferred by the order.
Thank you. We certainly had so much to cover. We didn't even get a chance to do commercial. Next time, perhaps we'll be able to do that. Thank you for tuning in to The Law Matters. We hope that you'll be with us next time, because certainly the law matters to you.